Yeah, we're going to get going here, and just others will join as we start moving along here. And I want to say welcome to this webinar, and really excited to have Scott Bunce and Harry Barth here. Scott is a Vistage Chair doing great things. Harry is the founder and senior managing partner of the asset protection, estate planning, and business planning firm Barth Calderon, talking about the Corporate Transparency Act. Very big deal. There's a lot of misinformation going around about it. So we'll learn about that. And I want to, Scott, start with you and just talk a little bit about what you're doing there with Vistage.
Sure. So I am in the greater Atlanta market, and I lead a peer-to-peer advisory group of about 12, 13 members. And these members are small business owners, CEOs, or senior executives that are looking to do a couple of things. First off, they're looking to share their knowledge and help other people solve business issues. And they're curious and they're vulnerable and they want to solve their problems with a group in a boardroom style setting. So it's very hard as a small business owner or senior leader when you have an awful lot of things going on and you're at the top of the pyramid. You're having to make tough decisions, people that you ask inside your organization, or maybe other groups that are related to your groups will give you very biased opinions on what it means to them. But in my group, nobody is in the same business. They're all in the same boat, being owners, senior executives, CEOs. And while they might have a lonely feeling, they get together with me once a month. We hash out problems. And then in between meetings, I act as a business coach for them as well. But I am really excited for today and getting Harry's feedback. I know I'm going to learn something, and I think I could probably share it with my members as well.
What wonderful. I want to tell everybody as we move into Harry here that that the information I'll put up there to get connected to both Scott and Harry as we go along and chat. And if you're watching this, because we're going to replay it, wherever you're watching it, either up here or down here, will be the contact information. Harry, what do we need to know?
Okay, well, thank you. It's great to be here, and hopefully we'll bring everybody a little bit into the light about a very, very important law that, surprisingly enough, the government has done a lousy job in communicating about, but would probably do an effective job in punitive aspects of it. So we're going to learn about that today. So first off, one definition that I think that is critically important is that you'll hear me use the term, Scott, FinCEN a lot. That's the Financial Crimes Enforcement Network, and it is a subdivision of the United States Department of Treasury, and it's the FinCEN network that is responsible for implementing and enforcing the Corporate Transparency Act. The Corporate Transparency Act was passed, a bipartisan legislation that was passed in 2021. Signed by the president, and was delayed in implementation until January 1st, 2024. I think you'll understand why it was delayed a little bit as we get into it somewhat. But the purpose of this basically really got started back 9/11. And the government since 9/11 has been trying to ferret out individuals that have been involved in terrorist financing, money laundering, tax evasion worldwide. And as we've learned from the Pandora Papers, Panama Papers, a lot of people are hiding behind shelf companies, or they, companies that are formed that they sit behind, and nobody knows who they are. And it's through those types of activities where these nefarious acts take place. So the purpose of the Corporate Transparency Act is to build a non-public registry of small businesses and very important for our purpose today, who are the human beings behind those companies for the use of law enforcement, both domestically and internationally. So it's a registry of who are the humans behind the businesses. Now, that's very, very important to understand as we begin to learn about the aspects of the Corporate Transparency Act. Who does it apply to? Well, it applies to every single non-exempt business in America. So the best guesstimation is that there are 33 million pre-existing businesses that must comply with the Corporate Transparency Act, and every new business opening in America must comply with the Corporate Transparency Act. When I say businesses, let me define businesses, Scott, a little bit. So it's every corporation, limited liability company, limited partnership, limited liability partnership. If we have to go to the Secretary of State in Georgia and say, hey, we want to form an entity, and the Secretary of State puts a stamp on it, that is an entity, if it's not exempt, that must comply with the Corporate Transparency Act. Is the government serious about it? All right, so let's take a look at what happens if we don't comply, and we'll learn what compliance is all about. Really interesting. So the moment we're not in compliance, corporation or LLC is not in compliance, and I'll talk about what it takes to be in compliance, a $591 a day fine begins to run, no cap. So if we're 10 days beyond compliance, $5,910 for each violation of the act. In addition, if it's willful, like I'm not complying with that act, it's a $10,000 criminal fine and up to 2 years in jail. It's a felony. So, are they serious? You bet they are. Are there challenges to this act? I want to get these out of the way before we get going and get to the exemptions. There's a couple challenges. There was a court case, National Small Business Association versus Yellen, that was heard in the Northern District of Alabama, with an attempt to declare the Corporate Transparency Act unconstitutional. And in a summary judgment by that judge, the judge did say that it was unconstitutional because in the court's opinion, Congress did not have the authority to pass this act. It only applies, it's very, very narrow. It only applies to if you're a member of the National Small Business Association. It has already been appealed by the United States to the 11th Circuit in Georgia. And it's not our best intelligence. I've been doing this close to 50 years. It's our best intelligence that the 11th Circuit is going to overrule the Alabama judge. And we don't expect any other district courts or circuit courts to declare it unconstitutional. The other thing that we have is there's one other case that just got filed. It was Boyd versus Yellen up in the Federal District Court of Maine, and same thing, trying to attack the constitutionality of the Corporate Transparency Act. The gravamen of that case was that the ability to regulate businesses belongs to the states and not to the federal government. And you'll see how this applies as we go through the logistics of the Corporate Transparency Act. My humble opinion is that most modern Western economies and most modern Eastern economies already have the existence of the of a version of the Corporate Transparency Act. We even need to put our driver's license together to do a notary in America or to get a loan. So I'm not so sure that, and most money aspects of the Corporate Transparency Act will be declared unconstitutional. I think there may be some aspects, Scott, that I'd have to get tweaked a little bit. The penalties are egregious, and you'll see how they come about, that to me are quite a bit unfair. That being said, let me just repeat. There's a line in the sand. It's January 1st, 2024. All new entities formed after January 1st, 2024, Scott, from the date that they are born at the Secretary of State's office, there is 90 days to comply with the Corporate Transparency Act. Important date. So if we form our entity on March 27th, all right, Secretary of State says your corporation, your LLC is formed. 90 days from then, it must be registered with FinCEN. For all of the companies, all of them, I don't care if they formed 50 years ago, If they're not exempt, formed before January 1st, 2024, under current law, we have until December 31st of this year to bring them into compliance with the Corporate Transparency Act, or all the penalties begin to apply. Okay. So before we get into all of the compliance and how it works, which in some cases is very simple, Scott, and in some cases is quite complicated, let's talk about the exemptions and how they would impact your constituency and all the people listening in with us today who overhear our recording. So this act is targeted to small business. It is not targeted to large business because it's behind the hair salon, where Jill and Jack's hair salon, two people in that Georgia S Corporation, it's in the back room where they're a cartel, may have laundering money through the hair salon. That's where those activities take place. They don't take place in large companies. So as a result of that, let me go through the exemptions for things that organizations that don't need to comply. So first of all, public company. The New York Stock Exchange, American Stock Exchange, NASDAQ. Hey, we know who all the board of directors are. We know who all the C-suite people are. They've been fingerprinted, background checked. We know everything about them. We know who the human beings are who are running those companies. They do not need to comply. So public companies don't need to comply. SEC registered investment advisors, those that provide investment advice and do financial planning, don't need to comply because between FINRA and the SEC and state regulation, we know who they are too. So we're not too. Same thing with venture capital advisors, venture capital fund advisors. Then we have highly regulated financial institutions, banks, credit unions, registered securities broker dealers like Merrill Lynch, Morgan Stanley. They don't need to comply. Again, for the same reason, we know who they are. Trust companies do not need to comply. They're highly regulated. And trusts themselves, which are not birds of the Secretary of State's office, do not need to comply. But you will learn that if a trust owns an interest in a company that needs to comply, then the trust needs to comply. And we're going to walk through that. And that gets quite complicated in getting it done. Political organizations, nonprofit organizations do not need to comply. And then also subsidiaries of exempt entities don't need to comply. So if your entity is exempt, a wholly owned subsidiary of that entity is exempt. And the one that affects you most likely and your members and other people that you come in contact with, Scott, as we'll talk about, is they call the large company exemption. So this is an and, not an or. So 3 conditions have to be met. The company has to have at least 20 full-time employees as defined by state law. So not 1099ers, not part-timers, full-time employees, 20 full-time employees. It has to have its office in the United States of America, and it has to have at least $5 million worth of gross sales. So if it has $5 million of gross sales, 20 full-time employees, and their headquarters are in Atlanta, they don't need to comply. But it's interesting when you look at that. Let me use my law firm as an example. So my law firm, we have over 20 full-time employees. Check. We have our offices in the United States of America. Check. We are over $5 million of gross sales. Check. So Barth Calderon, the law firm, does not need to comply. But Harry, who's an asset protection, estate planning, business transactional lawyer, I have 12 entities, LLCs, and limited partnerships that I own. That own my real estate, investments. You do real estate, own my investments, own intellectual property, own other businesses that I own. These are not subsidiaries of Barth Calderon. These are other brother sisters to Barth Calderon that Harry owns. Every one of those needs to comply. And if we've done proper estate planning, asset protection planning, you don't want to have too many eggs in one basket. We've moved the IP out. People own real estate, as you know, they lease it back to the operating company. All of those entities, with long as proper planning have been done, need to comply. with the Corporate Transparency Act. Okay, so what we're going to do, Scott, is let's build a new company. We'll call it Scott Harry Co. All right, and it's going to be an LLC. Um, it'll be a Delaware LLC that we authorize to do business in Georgia. And what will we do? Of course, we're going to manufacture widgets. What else will we manufacture? And we have two DBAs. Widgets are us and widgets are them. And we're going to form this entity, now around April 4th, 2024. And so on April 4th, 2024, Secretary of State of Delaware said, we are good to go. That's all exciting. So we're not exempt. We don't meet any of the exemptions for the Corporate Transparency Act, as most companies, a lot of them will not, especially mostly new companies will not. So we need to comply. So what do we have to do? So the first thing we have to do is we have from the day that we were formed, we have 90 days now to do this. We need to file the company with the Financial Crimes Enforcement Network. We have to tell them we formed this company. It has to be done electronically, right? And we'll talk about the logistics later on how organizations like ours help people file and determine who needs to file. But it starts with the company. And very important, Scott, in our company, it's the company that is responsible for all the CTA filing aspects of the company. Not you, not me, the company. All right. So what do we have to give FinCEN about a company? Well, the first thing we got to give them, we got to give them our name. All right. Scott Harry Co. LLC. Okay. We have to give them the name. We then have to give them all of our DBAs. Doing business as widgets are us, doing business as widgets are them. Then we must give them the actual physical address of our company. Not the lawyer's office, not the accountant's office, not the UPS suite, not the post office box, the physical address of our company. Now, if the physical address of a company is virtual, it's coming out of your house, Scott, it's your house. Or the apartment that you live at must be given. And we must give a unique identifying number. Most times, 9 times out of 10, that's the federal EIN number that we got from the IRS when you and I, went to the lawyer and they set up the company for us. So we have to give them that number. If it's a single member, tax disregarded LLC that did not apply for an EIN number, then we must give them our social security number. All right. So that registers our company. All right. With FinCEN.
Is there a fee to register?
No. And it's a one and done, not an annual filing, but you'll learn about changes. There's no fee for FinCEN, but it's very few businesses are going to be able to do this themselves. You'll learn why in a few minutes. And to give you an idea, the AICPA, the CPA Organization for America, has told all their members, all the CPAs, don't go near this with a 25-foot pole. It's the unauthorized practice of law. And you'll see why it's a legal bird. And remember, if you don't comply properly, it's a felony. So you want to be under attorney-client privilege, and you want to make sure you know how to comply properly. It's one of the burdens that are being placed on small businesses in America that I don't agree with. But it is what it is. But let's continue on. So now we have our company. We've got Scott Harry Co. LLC. We've got it with FinCEN. Now the company has to assure that it's any owner of our company that owns more than 25% is now known as a beneficial owner of interest. They're called a BOI. We must report. So Scott, you own 50% of the company. Harry owns 50% of the LLC. So we own over 25%. We've reached the age of majority. We now need to report. The company reports us as beneficial owners of interest. So what must they report for us? Well, they got to put Scott Bunce, your name. We must give them your home address. All right. Now, again, no lawyer's office, accountant's office, post office box, UPS suite, your home address. And we must upload to FinCEN a color PDF of your driver's license, non-expired, or your passport, non-expired, must. All right. For each beneficial owner must report. Now, a little bit of a, we'll call it a trick. So we're gonna get some tricks for people today. Something that the law firm can't do for you, Scott, and you need to you go to the FinCEN website, and Paul will put that up in the chat. It's www.fincen.gov. And go there and open up an account. So you go to Scott, you open up an account, and you usually can't do it. They want, all the authentication comes to play. Where'd you go to high school? Where'd you go to elementary school? What was the color of your first dog? Two-factor authentication to your cell phone. You put in all that information, your name, your address, and you upload those documents. FinCEN will grant you a number. So you'll now have a FinCEN identifying number. So on every scenario where you have to comply, rather than putting your home address and your qualifying documents every single time, you could just put in Scott and your number, and that'll be acceptable. So that's very important. So I would suggest that all of us, I got mine, a couple of months ago, everybody get a FinCEN number. So we got to go on. So we got to continue. So we now have the owners. All right. So if we have a third owner, let's say we had Paul, and Paul was a minor. So you have a third. You got to report. Harry's got a third. He's got to report. A minor under the age of 18, depending on the age of majority in the state, they don't report until they reach age 18. But the parents of the minor need to report. So we have the two parents, or one parent, or two parents, and is it one parent or two parents? What if the parents are divorced and the minor owns it? Well, both parents need to report. But there's another aspect of it, and another aspect of it that's quite significant. Anyone with substantial control over our company must also report. It has nothing to do with ownership. It's ownership and control. So let's say, Scott, we decide that we're going to hire Polco to be the manager of our LLC. All right. We're passive investors. We own the company. We have Polco is going to manage our LLC for us. Polco is a Georgia S corporation. And it's, not a bad sized company. So it does not own any of our company, but it has substantial control over our company. That's a legal determination, substantial control. So now what has to happen? So Polco must report that it owns our company, must assure that Polco reports. What do they have to report? Scott, the CEO has to report. The COO has to report. The CFO has to report. And anyone in Polco that has any substantial authority to make a decision must report. If Polco has a board of directors, Scott, and the board of directors can remove and replace any one of the C-suite people, every member of the board of directors needs to report as well. Oh my God. Now, we've done some estate planning, Scott. We don't want your 50% investment to go through probate or through surrogate court, God forbid, in the event of your death, or through a conservatorship in the event of your incapacity. We've done some asset protection, some estate planning. So we wanted to take your interest in Scott Harry Co. and we want to put it in your trust. Typical, it's where it belongs. All right. So we put it in your trust. And sometimes we expect this to really grow, Scott. So maybe we put it into a gifting trust or an irrevocable trust for the benefit of children and or grandchildren. So it grows out of your estate, or into an asset protection trust because we expect it to be very valuable, or a dynasty trust. But we put it in a trust where it belongs. Now the trust, which itself is not a reporting entity, owns greater than a 25% interest in a reporting entity. So now the trust also becomes a reporting entity. So who created the trust? Scott and spouse. You need to report. The settlers of the trust. The trustees of the trust, who can move things around inside the trust, they need to report. If there are trust protectors, they need to report. The beneficiaries, if they've reached the age of majority, they need to report if they're current beneficiaries of the trust. If we have a trust protector, which we have in some trusts that can remove and replace trustees, they need to report. And sometimes we have something which is called a power of appointment, which allows a surviving spouse to redirect which way the money goes in the event of their death. Some flexibility in the trust because they hold that power. The person holding that power needs to report. Started out simple, but it's not so simple anymore. And there are no exceptions to this. None. None. If we don't have that filled in by the 90th day, it's $591 a day. Now, there's a couple more. Since January 1st, there's something also known as the company applicant. So the company applicant is who filed the paperwork with the Delaware Secretary of State. So let's say you came to my law firm and my paralegal, Cheyenne, sent the paperwork over to Delaware to get that stamp for us to have Scott Harrico come to life. Well, Cheyenne, who is the filing person, must report that she filed it. I know, Scott. And if I'm the attorney that recommended that we form the LLC, the supervising attorney, I must also report. I've had to report over 200 entities since January 1st. Now, that company applicant aspect does not apply to the pre-existing businesses that are in effect before January 1st, 2024. They just have all the other people to do. God bid try to figure that out. It's going to be hell on wheels. So I was talking to a Vistage Chair in Texas. And we're talking about the Corporate Transparency Act. And we'll use this as an exemplar of what happens. He says to me, a lot of my members, they're in the oil and gas business. Of course, everyone in Texas is in the oil and gas business. And he says to me, and when they drill a well, Texas, usually it's a special purpose LLC because those things can blow out. People can get hurt, putting up the rig. There's all kinds of danger and risk associated, pollution problems. So we want to, from an asset protection point of view, and we design these things for them, we want this to be a single purpose LLC. Makes sense. That single purpose LLC, of course, is a new entity, doesn't have 20 employees, doesn't have 5 million gross sales. Of course, their office is in Texas. It has to comply. So that's our complying entity. Now, usually when people invest, we have investors who invest in that well. They don't invest individually because of liability. So they're usually an LLC. So LLC 1, 2, 3, and 4 are the investors in the oil well. So they each own 25% interest. We have 4 owners. Now, of course, we have 5 owners. Then it's 20%, and none of them need to report. But if we have 4 owners, it's 25%. They need to report. So let's just use 4. So all 4 of those LLCs are now reporting entities, and all of their owners need to report. And the managers of those LLCs and the manager of our oil well needs to report. But usually, as we know, Scott, they're done by holding companies. The holding companies they may have 50 oil wells that are held by a holding company. So the holding company needs to report. And the owners of the holding companies usually have their stuff inside their dynastic trusts or trusts. All of it needs to report. There could be 70 reporting entities from that one oil well. My God. So let's just examine something together. So a new entities, when we formed Scott Harrico LLC, Scott, we pretty much knew who's owner, who's control, name of the company, all the things that are involved. So it's not quite as challenging when we're forming a new entity. So the lawyer, there should be a lawyer, by the way, not all commercial for lawyers, but there should be a lawyer, should determine who the owners are. If they're held by trusts, which they should be, they have to look at the trust to see who are the players in the trust so we report properly. And then you have to determine legally who the control interests so they can report properly. And then you take that and you go sit down, because they only take it electronically, at the Byzantine FinCEN website and load all that information in. So usually people will go to a service. We have one of them, for example, charge $250 and they'll load it in to the FinCEN website and the lawyer will make a little bit of a map. So that's new ball game. Okay. Now, that information, again, I want to repeat, is not public. And two, it's one and done. Scott, once we have our LLC filed with FinCEN, absent changes, somebody moves, you have a new address, new driver's license, new passport, we're done. But you see, businesses, as you and I know, they're not static. People die, stuff goes into probate, trust administrations, parents make gifts to children. Every one of those changes, we only have 30 days to bring the change to FinCEN, or we are out of compliance at $591 a day. Now, looking back at all of your members, me, all of our existing businesses, my God, 5 pieces of real estate, your clients have 5 pieces of real estate, they use for vacation rentals. Each one, let's say, is a separate LLC. Every single one of them is a required reporting entity. And they're in existence prior to January 1st, 2024. So we have till the end of the year to bring them into compliance. Sometimes that's not so easy because sometimes, the spouses are divorced. One spouse doesn't even know where the other spouse lives anymore. All right. Somebody died, it passed through administration to a beneficiary. That beneficiary put their interest in a trust. All of that has to be searched out. There are no exceptions. We can't say, hey, we required 70 BOIs. We have 68 of them. 2 are not there. FinCEN has been instructed that that entity, our business that had that 70, is no longer is not in compliance and a $591 fee. So we have to get rid of those 2 people or get them to comply, which brings us to the next component. The next component is when we put together, like now, when we put together Scott and Harry Co. LLC, there are operating agreements for an LLC, as you know. For corporations, there are shareholder agreements. For limited partnerships, there are limited partnership agreements. There needs to be a new section in both the pre-existing agreements for everybody and for the new entities, the Corporate Transparency Act, where we, Scott and Harry, sign that we will comply with the needs of the Corporate Transparency Act. And we will say that if you're going to become an owner, if we decide to take our 50-50 and bring in Paul and give him a third, we reduce, our ownership interest and we bring in another owner, that owner is going to have to sign that they will give all their appropriate information to the Corporate Transparency Act, or they put our entity into non-compliance. Now, here's the spots of it that I think are not constitutional. So, for example, if Paul says, I am not complying, I'm not going to do it. Well, he's going to be subject to $591 a day fine. Plus, he, by causing us not to be in compliance, could be subject to criminal charges. We, our entity, because of Paul, is not in compliance, and we can be subject not to the criminal, but $591 a day fine until we figure out what to do with Paul. In other words, we should not have him in our entity to get things moving. This is, you and I become responsible for that. So not only do we have become tattletales, on Paul, we, the company, Scott Harry Co., have to assure compliance of our company. So what is this kind of the silver lining? So some of the silver lining that we see is that most of your members, people that we look at all the time, especially with the older companies, they're not in compliance. Their documents are old. They've been sitting in a drawer. You look at the cap table of that corporation. Ugh, it's not even close to what it really is. There's been transfers, there's been redemptions, there've been sales, there've been new owners added and changed, and people don't have, or many businesses don't have their legal documents up to speed. They're old. I look at them, ugh, they're not even close. This gives everybody an opportunity to take inventory and make sure that their critically important legal documents are up to speed. If there's a benefit, I guess that's a kind of a benefit that comes as a result of that. And also to add into the pre-existing documents and for new companies, the appropriate language to make sure that we're in compliance. So, for example, if you got a FinCEN number, Scott, you got a FinCEN number, it's Scott Bunce, and you have numbers, blah, 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 blah. It's the company, it's Scott Harry Co.'s duty to make sure that if something changes inside there, new address, move to a different state, the company must make sure that you update your information with FinCEN within 30 days, or our company goes out of compliance. It's company oriented. This is quite a bit of we've had nothing like this in America ever before. We also run into another problem, one that's more practical that we could both relate to. There's an awful lot of information that's floating around here, a lot of sensitive information. And it's usually being transmitted from client to the lawyer's office, lawyers to FinCEN. Encryption of that data, because there's an awful lot of bum players out there, bad guys. Matter of fact, on FinCEN's website, they were already putting the warnings out. Watch out for the bad guys who are trying to steal your information. Plus, now the organization itself, like my organization, has all that sensitive information. We usually have it anyway. What is the protection for that information for people that are moving all the sensitive data? So we have cybersecurity issues that are involved. We have ownership issues that are involved, and we have compliance issues that are involved with the CTA. And a lot of people that think that, well, it doesn't apply to me. I have more than 20 employees and 5 million sales. Almost universally, we have ancillary companies that have been set up for appropriate asset protection estate planning. One of the worst scenarios, I think, is perhaps, and we want to get this out there to everybody, the chilling effect. In other words, it's appropriate that oil well should be done as an LLC. It's appropriate that short-term vacation rental should be an LLC or a limited partnership to limit liability. And if people are not doing that because they don't want to make a disclosure to the Treasury Department, they're exposing all of their assets to the claims of third-party creditors that should not have been there. If they don't have their stuff properly done, they're not getting discounts for estate planning. They don't put stuff in trust. They're moving things into conservatorships or into probate courts where they're not necessary. So it's kind of like you just need to do it and get it done and keep it up to date. And so that is, by the way, the Corporate Transparency Act. And it's interesting. Do I think it's going to be around? I do. Do I think it'll be around? There's one bill pending in Congress. Let me just share it with the constituency before we go to questions and answers. And that is, there's a bill. It's passed the House, not yet taken up in the Senate. Hopefully it will be, and not signed by the president. And that is mostly around extensions of time for CTA. So one extension is, when they first started CTA as of January 1st of 2024. When you formed an entity, Scott, you had 30 days to comply. That was extended to 90. Thank God. We now have till December 31st, 2024 for 33 million, which you now realize could be 200 million transactions. December 31st, 2024. The bill, should it get into law, extends that to December 31st, 2025, adds another year onto that. But with that, in that bill is some real draconian language. And it's hard to even understand for any of us that speak English. But what it basically says is that it's an instruction from Congress to the Financial Crimes Enforcement Network, just like what I told you. You cannot and you will not accept anything unless it's 100% complete. So if someone says, I got 68 of the 72 we can't get, you are to reject that and start the $591 a day fines. So, wow. Now, I don't think that's constitutional, by the way, and some aspect of it. Right now, the constitutionality is being worked on from whether Congress has the authority to do this. As you can see, the main action says, hey, look, the forming of limited partnerships, limited liability companies, and corporations is a burden of the states. And this is interfering with the state's ability to do that job. So Congress doesn't have the authority. And the other one is Congress just didn't have the power. It's not interstate commerce. So, but we don't, my opinion is that those cases will fail, but there will be some modifications to the CTA. It's very, very challenging. And with that, we'll go to questions and answers. Paul and Scott. So Scott, fire away questions at me. Paul, fire away questions. And if we have any other questions, let me know.
Yeah, I mean, people can put their questions in chat, and I've got a few that were sent in earlier. And Scott, feel free to jump in too. But Harry, you do a lot of talks to apartment associations for a lot of reasons, asset protection, estate planning, and the CTA here. And the issue that comes up a lot is this is a big deal as people are trying to get property from one generation to the next. CTA is now part of that process, right? The people who are inheriting, for example, parents pass away, 4 or 5 kids get property and so forth. It's in a trust or whatever.
There's a trust that all the details of if a child has more than if the inheritor has more than 25% ownership interest in the entity, or they're creating an entity to receive the inheritance and they own more than 25%, yes, they are subject to all the reporting. And the difficulty, you can see, Scott, this puts a burden directly on small business. It takes hours of time. I mean, I'm just thinking for myself. I have 12 entities. Just 12 entities. And for myself, I'm a lawyer. I do this for a living. It's going to take me time. Every single entity has to be evaluated, who the owners are, who the controllers are, all the aspects of my trust. And I have several different types of trusts that I utilized over the years for asset protection and estate planning purposes. Ugh, and all of that. First of all, it's like you feel uncomfortable, queasy about giving the government all that information. They claim that they will protect it and there's serious fines and and no one can get to it and it remain private only for law enforcement use only. But do any of us really trust that? I don't know. Donald Trump's tax returns got out, and of course they're putting that person in prison, but they still got out. Now, on the other hand, Scott, where we live, social security numbers, driver's license, pretty much the states and the feds know about it anyway.
Yeah.
So I don't know. But that's a concern that I have. But the answer is yeah, as we move from generation to generation, those changes right now, from the moment, see, someone dies, it's either going to go into probate court, Scott, or it's going to go through a trust administration. Those things take anywhere from a year to 2 in many cases. At least given what we know, it's not when someone dies, it's when the end of that administration happens or the end of that probate administration happens, when it's transferred from the estate to the beneficiary. That beneficiary now has 30 days to report to FinCEN, otherwise it's out of compliance. If it's an entity, if it's just in trust and a piece of property moving in trust, then the answer is no.
Scott, your quick takeaway on this?
Yeah, well, first off, I think the fact that this act has the word transparency in it is a misnomer in itself. Because until this, I was certainly not aware of this. And immediately I think of the LLC that I'm doing work with Vistage is in, I think, and you rightly mentioned it, Harry, I'm in the vacation rental business on top of a couple of other things. And I have partners that own, and I've got family members that are involved, and there is family trusts, and my head is exploding just listening.
Yeah.
Now, you mentioned at the beginning that it's something that typically an individual isn't going to be doing this, and they need the assistance of a lawyer to do. Why is it that, let's say that they were capable enough to do it themselves, but why would they need a lawyer?
They don't need, they could do it themselves. All right. So let's start there. You can sit there and you could do the analysis. So you have to analyze, um, one, is it exempt or not exempt entity? That's pretty simple. Check the box. So if not one of the 23 exemptions, it's not there. And in some cases, it is simple. So if you just have a piece of property in a living revocable trust, is not subject to compliance. It's not an entity that was formed by the state. So now we have the entity formed by the state. So every owner over 25% must put in their information. The entity has to get registered. You can figure that out. You can upload that. The ownership, for the owners starts to get a little bit more complicated. Sometimes it's simple. It's just Scott. But then Scott properly put it in his trust. Now, Scott, successful business owner, successful businessman. Trust is not so simple. You have different beneficiaries, you have different players, you may have investment trustees, you may have distribution trustees, you have who created it, who holds powers. That may be difficult for an individual to evaluate. Then the other issue is control. So sometimes it's easy. Scott, an our LLC, it could just be Harry and Scott are the managers of the LLC. No problem. But let's change it a little bit. We got 1/3 owned by Harry, 1/3 owned by Scott, 1/3 owned by Paul, 33rd, 33rd. And we have our other 1%. All right. And we're non-voting. And the other 1% has the voting share, has the control. Now that 1% that has control, we have to determine, do they have substantial control over our company? That's a legal determination. You could do it. You'd be safe, just do it. You say, okay, but they're a corporation. Ugh. Now you got to go in behind the C-suite people and the board of directors. So can you do it? Sure. People could do it. And let me give you economics of it so you understand. So when we do an entity now, and we do hundreds of entities a month, we include in our fee corporate transparency analysis of who the beneficial owners are and who the entities are and who the controlling people are. So we do that analysis, and then we will then take that analysis with client approval, and we will give that to a service that we have that will then go on the FinCEN website and file it for them. Or they could sit there on a Sunday and spend 6 hours doing it. It's up to them. It's perfectly fine. That's a new entity. All right. And when you file a new entity, you could have done it on your own, but then you have the company applicant. You got to put all that stuff in. What's really challenging, Scott, is the older entities. All right. So every one of our pre-existing entities, all of that information needs to be ferreted out. So there, what we've done, and other attorneys have done different things. You don't have to use a lawyer, but we say, hey, look, for $595, we do that entire analysis of that entity. We have to look at the estate plan. We have to look at the operating agreements. We have to look at the shareholder agreements, power, ownership, right? And make a map. Then for $250, we file it with FinCEN. So you can do it yourself, or you can engage a firm like us. All in's about $750, and we take care of all of that on behalf of somebody. It's kind of like, could you form your own entity? Sure. Can you write your own buy-sell agreement? Sure. Can you do it? Sure, you can. It's kind of easier, I think, and better. But the key to that, my thought is that there are criminal penalties associated with this and a lot of fines. It's better to operate under attorney-client privilege than not to operate under attorney-client privilege. And I think that makes a big difference. But, is there a gun to anybody's head to use a law firm? No. Should they? Most likely.
Yeah, makes sense.
Makes sense, but they don't have to. But they have to comply with the law.
Okay.
All right, you got it.
Great information. No, Harry, thanks. Scott, appreciate you making this happen. And thanks everybody for being here. We're going to get the replay out to everybody that signed up and attended. So look for that in the next few days. You can have it, refer back to anything, and much appreciated, both of you.
All right, guys, take care. Thank you so much, Scott. Pleasure to meet you.
Thanks, Harry. Thanks.
Scott.
Okay.
Bye-bye.
Bye.
Let me show you who I can be when I'm in power. Let me see what you will believe. I've got the power to fulfill your negativity. I'll sing it louder, 'cause I'm in power. I'll sing it louder.